Good afternoon, Mr. Mitchell. Would you like to start again with your submissions?
Thank you very much, my lady. Before the adjournment, was taking the board to the issues relating to the Court of Appeal's practice direction for these appeals that they have been hearing since the pandemic started. Of course, that is not my learned friend's point. His point is much more concerned with the permissive nature of the Constitution, allowing the Court of Appeal to sit elsewhere, and the fact that he argues that the Constitution doesn't make any such provision for the court, and that the Supreme Court ordinance restricts the jurisdiction to the Turks and Caicos Islands, which I add is hardly surprising. I'd like to pick up, however, on how the Court of Appeal issue is actually not helpful to any of the decision making that needs to take place, because as you will recall, judgment page 164, paragraph 164, page 339 of the electronic bundle, and that's in the decision of Justice of Appeal Adderley. He turns to deal with the ordinance and the practice and procedure rules. He references the rules in relation to venue at 165, having set out the statutory provision from the Constitution, which permits the Court of Appeal to sit either in the islands or such places outside. And then the rule, this is for your notes of necessary electronic bundle 584, the hearing of an appeal may take place either within the islands or at such other venue as the President of the Court may appoint, having regard to all the circumstances relating to the appeal and representations. Clearly, as Justice of Appeal Adderley points out in the next paragraph, this was back at a time in 1975, 45 years ago, when Parliament must have intended that judges would sit physically at the same location because there was no capability of remote hearings, not even the smallest of hand clouds in 1975. That one venue may be chosen at a time, not several, simultaneously. At that chosen venue, all the judges may sit physically at the same time to do the court's business. And then he makes reference to Rule 6, which is important to draw the distinction between what is now happening in 2020 and what I may describe as virtual courts, and what was anticipated in 1975. The rules, and you'll find Rule 6 again on the electronic bundle, page 584, do not authorize the registrar of the Turks and Caicos Islands to administer a hearing taking place physically outside the Turks and Caicos Islands. Rule 6, I would respectfully suggest, requires the registrar to forward the record of appeal to the registrar of the court in the territory in which the appeal is to be heard. It provides that all further acts in connection with the setting down of the appeal, the hearing and the hearing itself, shall be performed by the registrar of the Court of Appeal at which the appeal is heard. That is a material distinction to help us in our route to understanding Regulation 4.6 and what it actually is meant to achieve, what its purpose is, what its mischief is that it's aimed at. Here, the Court of Appeal, although it's argued constitutionally they're the only ones entitled to sit abroad, they are entitled to sit abroad, but when they sit abroad, they are actually physically sitting in another location with the registrar of that location undertaking the work of the registrar in the Turks and Caicos Islands. If you compare and contrast that with the proviso in Regulation 4.6, and then, of course, with the practice direction, in particular practice direction number 3, which you will find in the bundle 7.9, my lady, your lordships will come no doubt to the conclusion that we are dealing with two different animals. One is the creation of a authority necessary in the Constitution for a court to exercise the jurisdiction of a Turks and Caicos Islands court in another jurisdiction. That's the Court of Appeal with its practice rules. And the other being, well, you happen to be outside the courtroom, and arrangements need to be made so that the courtroom can hold the court whilst you, and I'll use the phrase unapologetically, or the word unapologetically, are beamed in so that you can complete, I may again use my word, the jigsaw of the jurisdiction of the court in the Turks and Caicos Islands. So that's the answer to the Court of Appeal point. In relation to the Supreme Court point that the learned friends made, which is, of course, that the court has no authority to sit abroad. We submit shortly that he is mixing his place with his jurisdiction. Of course, Mr. Justice Harrison can't be a Turks and Caicos judge in Jamaica, no more than Mr. Justice X may be on holiday in France and making decisions about England, but not France, in France. It simply beggars belief to think that that's anywhere near the suggestion, A, that we're making, or B, that the regulations were seeking to create that. What the ordinance is aimed at, Bundle 603, is the jurisdiction of the court. And it's quite clear that the jurisdiction of the court is to establish a court by statute that has authority over the territory in which that jurisdiction is being established. It doesn't define where the person who exercises that authority has to be as a matter of constitutional legal principle. He can only exercise the authority in the Turks and Caicos Islands. He is a judge, or she is a judge in the Turks and Caicos Islands. When he leaves the Turks and Caicos Islands, no longer a judge anywhere else, wherever he or she may be, but still a judge in the Turks and Caicos Islands, so that if an emergency is apparent and the judge is needed, the judge can make connection with the court registrar, and make such rulings, decisions, or issue. Have they lost me? I'm sorry. I think that everybody continued to hear me. I was just told in the room that one of my lords had gone. So very simply, I cut to the quick. The Supreme Court ordinance is not about venue, it's about jurisdiction. And it doesn't mean that a judge can't exercise authority over the jurisdiction from somewhere else. I raise this with diffidence and plainly ready to be put right, but I'm inferring, if no more and no less than this, that Lord Kerr went to Northern Ireland whilst still sitting in the Supreme Court, and that when in Northern Ireland, presided or sat in cases that touched and concerned England and Wales. My lord.
The Supreme Court is the Supreme Court of the United Kingdom. Lord Kerr has jurisdiction throughout the United
Kingdom. It is, but I seem to remember that the Constitutional Reform Act made some reference to it being a court of the United Kingdom, but decisions of the court in relation to England and Wales are decisions in England and Wales, and decisions of the court in Northern Ireland are decisions in Northern Ireland. It may be that I've misread it, and maybe therefore it becomes a bad point. But I simply make it as it's a throwaway, and it's made contextually in this way. There is no longer room for the appellant's case to look to 16th to 19th century thinking, as we pick up at paragraph 23 of our case on bundle page 459. We have a 21st century problem, and we need to apply 21st century solutions to that, and not 16th to 19th century ones. And their reference to the need for justice to be physically at home no longer survives, or to be at the door of the subject physically, because it can now be at the door of the subject virtually and remotely and efficiently. I'm going to come back to the impact of remote hearings when I deal with my learned friend's equality of arms point. But it's important in the context of trying to establish what is happening, to look at where the authority is being exercised, where the jurisdiction is being exercised. He has no authority. The judge abroad has no authority without the court. And the court is the jurisdiction over which that judge is appointed. Can I, in that context, invite you, please, to look to Section 51(1)(a), as now is, of the Criminal Justice Act following the Coronavirus Act amendments, which you will find in Learned Friend's bundle for at the easiest place, certainly as far as I'm concerned, at page 26. And may I just spend a moment or two, as I said, I was looking at that with you, because Learned Friend's reading of it is not mine, and I just want to make sure that this approach is right. A person may, 51(1), if the court directs, take part in eligible criminal proceedings through a live video link. That's 51. 51(1)(a), a direction under this section may be given for a judge or justice to take part in eligible criminal proceedings through a live audio link or live video link. And eligible criminal proceedings, 51(2)(c), trial on indictment. The exception comes, which is what my learned friend was referring to, in relation to limitations on use of live links. And if your ladyship, my lords, would go, please, to additional bundle, page 31. Learned friend's point when he dealt with this part of the schedule was that the conditions for allowing video proceedings only related to proceedings that are a summary trial in magistrate's court, and the parties agree. The fallacy in that, respectfully, is that this restriction, these conditions, are when the proceedings are to be, and I quote, conducted wholly as video proceedings. So in other words, if you go back to the parent section, section 51, the following is acceptable. One, that a trial before a jury can be conducted by live video link with witnesses and the judge connecting remotely. Only the jury, subsection 1b, are not able to take part through a live audio link. Of course, they must be together. They will be taking part via the audio link in the sense that the judge will be connected remotely, witnesses will be connected remotely, and indeed counsel could be connected remotely. And then I'm driven back to my introductory remarks about Scotland and the use of cinemas. I also understand, and I appreciate that I'm 4,500 miles away, that there is a trial in Woolwich at the moment where the judge, defendants and jury are in one court, but not all the defendants. Because of social distancing, some of the defendants are in an adjoining court. And so the only principle that I'm seeking to extract from this is that if a learned friend is trying to suggest that the submissions that were being made include the lack of constitutionality of a judge being able to sit remotely. Well, with all due respect, the legislation in the UK, as it is developing around the pandemic, is against him. Scotland is against him. And the fact that we are conducting remote hearings frequently and remotely around the globe, perhaps, is also against him. So he's driven really by his submissions into the corner of, well, it's not fair in a trial, and it's not fair if it's part way through a trial. Well, part way through a trial or part of a trial plainly is something that Part 8 of the amended Criminal Justice Act is contemplated, my reference to Section 51, number 1. And the alternative, given the uncertainty of pandemic, is that there is no conclusion to the trial. Because no doubt there'll come a time when it will be argued, as it has been a number of times already, that the trial should stop because of the time it has taken, which is a separate and distinct issue. So my learned friend, we respectfully submit, can't move the goalposts of the argument that the provision that allows the judge to sit remotely abroad, that's the constitutional challenge, should now be somehow extended to include the judge sitting remotely, although he does that under the guise of equality of arms, which I must come back to. But in any event, the principal position is that there plainly is a growing appreciation that the fact finder and the defendants or counsel or witnesses can be physically apart. And we submit that the Turks and Caicos Islands should be no exception to this growing exception to the normal principle of this all being together under one roof and in one room, that in order to facilitate the good health of everyone, to ensure that the disease is not transmitted any more quickly or any further than it has been, or in other words, to play our part in protecting everybody, that the judge can sit remotely. So that we're driven back all the time to this issue as to whether or not the judge can sit remotely but in another country. And we have forever maintained the submission that he's not actually doing anything in the other country, because the only way he can do anything is by completing the jigsaw or being connected to and part of the process in the Turks and Caicos Islands. My learned friend also, of course, mentioned the issue of coercive powers, suggesting that there was a distinction when he moved to deal with the ending point. Can I therefore, first of all, pick up on the issue of coercive powers and remind my lords, page 308, of what the President of the Court, Motley, said about this. And that's paragraph 54. Oh, 8. Paragraph 50. Sorry, I think I said 54. Paragraph 50, and then I'll go to 54. It follows from what I've stated, I do not consider Regulation 4.6 created any court to sit outside the Turks and Caicos Islands. The regulation, in my view, permits a judge, whilst outside the territorial limits of the Turks and Caicos Islands, to sit and preside over a trial which is taking place in a courtroom within the territorial boundaries of the Turks and Caicos Islands. In doing so, the judge, in my view, is doing nothing more than making use of modern technology. The coercive powers of the judge may at all times be enforced within the courtroom, which is the point, I think, that I'm seeking to make. Further, there is but one courtroom, and the judge who sits outside the territorial boundary is conducting one trial, which is taking place within the boundaries of the Turks and Caicos Islands. And then at 54, building on the one courtroom point, the effect of 4.6 is that whilst the court may be physically split, for all intents and purposes, it is a single courtroom within the territorial boundaries of the Turks and Caicos Islands. We are but one judicial committee of the Privy Council sitting in one place, I would submit. In my view, Regulation 4.6 is intended to make clear that there is, in fact, one courtroom. The judge's ability to make coercive orders is in no way compromised because the judge is sitting remotely. The judge's power to punish a contempt in the face of the court is not, in my view, effective. Even though the judge sits remotely, he is required to observe all the rules of natural justice and to comply at all times with the requirements of the Constitution. And to that I add, of course, one has to have a large sense of appreciation about the role of a judicial officer in these circumstances. If it doesn't work, it won't be done. If it isn't good enough, it won't be done. If the effect of working remotely isn't good, the judge will say so, because it's a matter for him. It's not, with all due respect, a matter for you to determine that the judge can't possibly do this. And I'm going to come, as you probably appreciate, I would have done, to the other side of the Edward Fitzgerald coin about how positive some judges have found the video experience. But if I may say so, one of the things that I can properly say now, looking at the screen, is that I can see my lady and the lordships a lot more clearly from close distance than I would in a large courtroom. I am seeing Mr. Fitzgerald in a way that if I was sitting next to him in court, I wouldn't be able to see him. I can see him face on. I can see him smirking and noting as we go, which we would not be able to unless it was done sotto voce, were we in court. And so I'll come back to it because it's not my experience, it's what other judges and what other learning is on this. But the fact that there is so much, my lord.
Yep. So, could I just bring you to page 675, which is the regulation, that's Regulation 4.6.
Yes, Lord.
And as I understand it, the second line elects to sit. You say that in the context of remote hearings, which this regulation is about, that
Yes.
is elects to sit virtually.
Yes, Lord.
And you say that he's electing to sit virtually at what location?
He elects to sit virtually at the court in Turks and Caicos Islands from wherever he may be.
Which court?
The court where the recorder, the registrar, facilitates the hearing. So we may be, I'm sure we would be back in the court that we have been sitting in, so that the television screen or the video screen would be where the judge is. It's funny enough how the Court of Appeal sat. You had an empty chair.
So therefore, the courtroom shall include any place where he elects to sit. Well, that's tautologous, because he's electing to sit in the courtroom in the Turks and Caicos Islands. And so it is pure tautology.
Lord, if I do nothing else in this appeal, I can't defend the strict reading of 4.6 because you do end up going around in circles. And the only way that 4.6 works, respectfully, is giving it its logical, purposive and mischief approach, because otherwise you do end up going around in circles, my lady.
I just wanted to wonder aloud whether the courtroom is something different from the court in this context. The courtroom being the room in which is a type of courtroom within a building. You can see that in other places. For example, afraid I made these notes earlier, so I can't quite remember where I found, but I word searched for courtroom in the electronic file, E718, paragraph 1. This is 718. This is about the Court of Appeal. You've taken us to this, I think, already.
Yes. Sorry, I just need to switch out of the other. I was in the official box.
Yeah.
I'm there. 718. This is the Court of Appeal's practice directions, which were issued in June.
Yeah, yes. And they're presiding together in the courtroom.
Yes, maybe.
And there's another reference similarly, 702. I can't remember what that was for a moment.
702.
Yeah, this is about testifying remotely,
yes.
And talking about when the witness isn't testifying in a place with a courtroom. That's more like a physical entity of a courtroom, whereas the court is something different.
We could sit down, spend time and define what all these words should mean. And sit is one very good example, because if sit is sitting in Jamaica to conduct business, then I'm not going to argue for the purposes of this appeal that he has the authority to do that. But if sitting in Jamaica as part of the court in the Turks and Caicos Islands, through the auspices of the registrar, into a courtroom where other people will be attending, well then I can argue and contend for that. You will remember that the President, 54, I think I may have just read this, Regulation 46, page 309, is intended to make clear that there is in fact one courtroom. He may have had his mind on his practice direction. Sorry. But it's plain that the regulation is not intended, does not have its purpose, and plainly therefore it's not the mischief of the regulation to create a court or a courtroom in Jamaica. And learned friends say, well, you know, because it doesn't strictly comply, if you read it literally, it doesn't comply with the Constitution, because we all agree nobody can hold court in Jamaica. Then you must strike it down. It isn't the entire answer, my lord.
Just to make sure that concentrating on the words "the courtroom shall include," I wonder whether that might have been meant to convey the idea that wherever the court is assembled, the judge shall be deemed to be considered in that place.
Well, that you will have picked up from the judgment, but I was quite concerned to emphasise my submissions that the word shall include were embracing rather than specifying in a particular way, a particular place. My lord will agree.
Can I venture a slight variant on my Lord analysis? I mean, subparagraph 6 has to be seen in the light of the proviso, which is obviously meant to govern 6. May well govern 5 as well, but it plainly governs 6. So that it only operates in a context where there is more than one place in which the court is conducting its hearing, and that the two places are connected by an adequate video.
Yes,
and if that's so, I wonder if it means that for the avoidance of doubt, when the judge elects to sit somewhere which only gives him contact with everybody else by a video link, then the place where he is actually sitting is also to be deemed to be part of the courtroom.
Yes.
It doesn't alter where the courtroom, as it were, essentially is, namely in the Turks and Caicos, but there may be a sort of annex to the courtroom which happens to be in Jamaica.
If I couldn't put it better myself, and I've been trying to articulate this sub part of the regulations for months, and my lord, that is another way of identifying that the intention behind the words is to allow a judge not in the courtroom to be remotely connected to the courtroom and to then take part in those courtroom proceedings as part of the court. I've dealt with coercive powers. I appreciate that. I think I may have an hour. The two practice directions on remote trials need to be considered. They're more in the context of equality of arms, but they sit here because they are part generally of the case. My lady, my lords, PD3 is at 679, and that's now being replaced by PD4, which begins at 692 and is the relevant part is at 696. Can I go first of all to 679? Again, just bear with me for a second. 679, general matters, sole discretion of judge, general matters 1, then sub 2. Sole discretion of the judge, having regard to the pandemic and the physical distancing protocols. So all the time, this is going to be obviously part of the judicial thinking, although we'll move to 4 because that's the relevant one now, as well as the health and safety of him or herself, court staff and court users. It's recommended that hearings be held remotely. 4. The registrar, this is part of the Court of Appeals judgment, and it's important to emphasize it. The registrar communicates the date. The registrar sets up the hearing and allows access. The parties shall be granted access. And then if I could ask you to go, please, to 681. That's 4, and then 4.6. Every defendant in police custody shall appear before the court remotely. And then if you would go, please, to 10, page 687. Defendants in criminal cases, as well as persons ordered to be produced in habeas corpus proceedings, shall appear remotely by video and audio link. The latter person shall be deemed to have been produced for the purpose. And then conduct of hearings, again important, the registrar informs the parties of the platform, attorneys to download the platform, the registrar to set up a meeting prior. There'll be a test run, rather like as before the board. The judge or magistrate shall not operate from the courtroom observing social distance protocols or from any other place the judge elects to hold the hearing, provided the registrar and every other person to the trial can access the proceedings remotely through the selected video platform. And then 5, where the hearing is conducted by the judge, counsel, witnesses, as well as the defendant should testify or give evidence remotely. And then there are other general matters I don't need to go into. 696, please, which is the relevant practice direction in force at the moment, though it's right to point out that because there have been no jury trials here since March, And my understanding is that yesterday the House of Assembly passed an amendment to the juries ordinance to permit jurors to sit in a different room to the counsel and the judge, so that they would then receive the evidence remotely in order to try and overcome social distance protocols. It's only relevant to one small part of learned friend submissions, namely the right to breathe the same air as the fact finder. Of course, isn't happening in Scotland either. But here, the new regulation, PD4, forgive me, beginning for my purposes, please, at 696, remote hearings enabled under Practice Direction 3 shall continue, but a judge may order in-person hearings or make an order for a hearing which is partly remote and partly in person. The discretion may be exercised by the court or upon application. The business of the court may be carried out either remotely or in person as the registrar directs. In a hybrid hearing, counsel may address the court or make submissions, and witnesses may testify from a place of remote access within the court building. There's then a reference to live streaming, and then criminal trials shall continue to be heard remotely unless the court orders it to be held in person or partly remote. Judge-alone trials shall continue to be at the election of the party or the court, subject to section 58. And then there are protocols about attending court, wearing of masks and so forth, which, by the way, is something that should be added into the mix, because it's all very well to argue that the defendants should have the right to be in the presence of the court, but we are in a pandemic, and they'll be wearing their masks unless the judge rules otherwise, and so will the judge unless he decides otherwise, and so will counsel unless he decides otherwise. And I, for my part, if I may be permitted the personal observation, would much prefer to see the judge, counsel, and the defendant on a screen sans mask than be in the same location as them with a nose to chin face covering. But that's a matter of personal choice. Some might say, as far as I'm concerned, that I'd be better off with a mask, whether I'm before the court on a video link or in person. But the hearing of judge-alone trials, page 700, unless it is inconvenient or impractical for defendants in custody to be physically present in court for pre-trial matters, all defendants shall appear in court for in-person proceedings. Notwithstanding this provision, no person shall be transported from prison custody to Grand Turk, and all criminal trials scheduled for hearing at the Supreme Court shall take place before a judge in a proceeding which may be conducted remotely, in person, or hybrid, partly remote, partly in person. Where a defendant is in custody, my lady, just so that the geography is clear, Grand Turk is the capital, so it's the administrative centre of government, but the commercial and tourist centre is on the island of Providenciales, and it's Providenciales where the trial has been taking place. That's where the judges tend to be located, but the Supreme Court also has a court on Grand Turk, and that's where the prison is. And so what the Chief Justice provided for was where a defendant is in custody, he shall stand trial before a judge at Grand Turk in a proceeding which may be remote, but notwithstanding the preceding 5 provision, a judge, whether due to his inability to travel to Grand Turk to conduct the trial by reason of COVID restrictions or other communicated reason, may decide to conduct the hearing from Providenciales by video link over a matter in which he is the defendant, forgive me, is at Grand Turk, whether or not he is in prison custody. So there is live recognition of the fact that there can be separation between fact finder and defendant, which in a pandemic is hardly surprising, provided always that one has in mind the interests of justice and the ability of the judge to carry out his oath sworn powers. If I may then move on to ending. One of the remarkable aspects of ending is not only did the judge at first instance, but also my learned friend fall into the failure, if I may put it this way, to tackle head on the particular paragraphs that are distinct and sit alone from any discussion arising out of the decision of the Supreme Court of Canada. The reason why the Supreme Court of Canada's position was important was that, as you will have read, they rehearsed what the British Columbia Court of Appeal had found without comment. And I always argued, and indeed it was the Court of Appeal agreed with me, that no court would rehearse without comment something with which they disagreed. But the reason that they didn't then move on to deal with it was, as my lords and Mr. Fitzgerald recognized during the course of exchanges over ending, that the ending decision in the Supreme Court, dealing A, with inherent jurisdiction of the court, and B, with the statutory provisions of the courts, of those provincial courts, were nothing to do with the principle in ending, which we have so wedded ourselves to during the course of this litigation. The reason for that distinction, we submit, is this. When the judge sitting remotely in the cases in ending was doing so, therefore, in another province, he was sitting in that other province and he was exercising authority of his province in the other province. So that was the very issue about which I have not engaged and do not seek to engage because it is wholly irrelevant. But as a build-up to that decision-making in the Court of Appeal in British Columbia, and can I take you please to, you'll find it in a number of places, Justice Appeal Adderley 345, our written case 463, and in the report itself 1359. The holding, and again, it was itself obiter in the Court of Appeal in British Columbia, but we submit it sets out a principle which it is hard to overcome, and that the Court of Appeal recognized this when they said, the President, I take solace from it, EB 310, Stolmeyer, I find it supportive, EB 325, and Adderley, EB 345, strikingly similar. And these words bear reading. As noted, this is in the appeal, the province has no objection to a judge who is outside the province conducting a hearing by video conference or other communication medium, as long as the hearing itself takes place in a British Columbia courtroom. If for reasons of convenience or otherwise, a judge determines that a matter is to be heard by telephone, video conference, or other communication medium, there is, I suggest, no reason why the judge, counsel, or witnesses necessarily need to be physically present in the province, as long as the hearing itself takes place in a courtroom in British Columbia. Witnesses and counsel, of course, will have the right to be present in the courtroom and cannot be compelled to attend to a location other than a courtroom in British Columbia. I don't know whether my lady's search for courtroom picked up this authority as well. Such a hearing, in my view, would not offend the common law rule that prohibits judges from conducting hearings outside of British Columbia. Although the judge may be located elsewhere, he or she would be exercising his or her jurisdiction and authority in a hearing taking place in British Columbia. The hearing would respect the open court principle, as interested members of the public and media would be able to observe the proceedings in a British Columbia courtroom. It will be up to an individual judge to determine when it's appropriate to conduct a hearing whilst outside the province. such hearings, I expect, would be rare and only arise in exceptional circumstances. I don't suppose he had in mind a worldwide pandemic, which might fall into the rare and exceptional circumstances category. And it's this part of ND that we submit strikes a chord with our submissions and is what we respectfully take away from the ND principle. It's nothing to do with the fact that it was class action litigation. It's nothing to do with the fact that there were a number of different judges in different provinces all striving to achieve an outcome that was relevant to the whole of Canada. It is simply and narrowly driven to the words that we find in these paragraphs, which set out and articulate what we submit Regulation 4.6 is to be read as seek to achieve. Now, if the next question is, well, if that's what was the common law, why bother with Regulation 4.6? The answer to that is, of course, that when a pandemic starts and few people with limited resources are seeking to identify issues that need to be resolved in order for the wheels of justice to be permitted to continue to turn or to start turning again, it may be hardly surprising that a common law principle such as this may not have been at the forefront of the drafter's mind. And so if I then move on, it's not, as a regulation we submit, designed to empower a judge with jurisdiction in another country. It's designed to embrace, in a small island with no resident judges, the opportunity for the court to continue to operate. And you will have picked up, I'm sure, that this does not, in those terms, challenge the Constitution. It is, using my phrase now, I think 3 times repeated, and I apologize, a method by which the jigsaw of the court in the Turks and Caicos Islands can be complete to enable the picture to continue, the case to continue. And I just mentioned, therefore, in passing, Justice of Appeal Stolmeyer, EB 325 and 326, and Justice of Appeal Adderley, EB 341 and 2. That point. It permits where the judge is, we submit, to be included in the courtroom, which I think is building on my Lord Lord Briggs's point, and the proviso we submit is supportive of the court being in the Turks and Caicos Islands, and is not in contradistinction to the regulations about Court of Appeals sitting abroad, to be read as providing a framework for the judge to be made comfortable in another country to be able to sit there. Can I move against that backdrop to a conclusion, therefore, on Regulation 4.6? The heart of the case is the challenge to a judge sitting remotely in another country, in brackets, but also remotely in the Turks and Caicos Islands. And we submit that to do this challenge, it needs necessarily to introduce a constitutional principle that the defendants have a right to the physical presence of the judge. And I've dealt with that by my references to cinemas in section 51. In the grounds of appeal, the appellants contended that the ordinary and natural meaning of the words to be applied would mean that the judge was basically setting up court in Jamaica. And that's my paraphrase, because the court has got to be somewhere. It can't be nowhere. So, and we submit that is not, cannot, and was not the intention well, it's issue 2, it's ground 3 because ground 2's been abandoned. The question here is the fair trial process constitutionally undermined so that it is right for the board to interfere at this stage with the trial process, because the judge can't be trusted to decide how to conduct the remaining, or some part, it may not be the remaining, some part of the proceedings as we move ahead. Whatever may be said by Mr. Fitzgerald in his submissions, the fact is that the appellants have shifted their case somewhat. They've moved the constitutional arguments about Regulation 4.6 from you can't allow a judge to sit abroad to you can't allow a judge to sit remotely. Do I feel emboldened in making that point to the extent that it becomes important for equality of arms? Yes. Originating summons, electronic bundle, page 8, declaration 2, a declaration that 4.6 contravenes the separation of powers. I accept that. It's the ad hominem point, encouraging the judge to conduct proceedings from Jamaica. Declaration 3, that it's ultra vires because it purports to confer power on the Supreme Court to conduct proceedings outside its territorial boundaries. Again, still on electric page 8. Although this was abandoned, nevertheless it's relevant, without the consent of Parliament of Jamaica to establish a court or courtroom of the Supreme Court of the Turks and Caicos Islands in Jamaica. All of that is important because, as I have respectfully submitted, the court has to be somewhere. And then within the grounds of their originating summons, EB9, paragraph 1, refers to the territorial jurisdiction and not to extend to sitting outside. EB11 is a reference to territorial jurisdiction, again at EB12, twice, paragraphs 15, 16, and then also paragraph 17, no constitutional power vested in the Supreme Court to operate outside its territorial boundaries. And then again, in paragraph 18, there's a reference to operating outside territorial boundaries, EB12. And then at paragraph 23, there's a reference to all substantive hearings, bar 2, taking place within the territorial boundaries, EB13. And so that, we submit, was the way that this argument started and continued, really, until, until written post-grounds of appeal submissions. And I can say that in this context, before the court below was all about extraterritoriality, including with reference to Mr. Misick, Queen's Counsel, making the point about contempt of court and what happens if a witness refuses to answer the question, what can the judge do in Jamaica? And then her ladyship, Ms. Justice Loban Jackson, in her judgment, at paragraph 5, EB 240, speaks of the complaint being about extraterritoriality. I'm not going to spend more time on her judgment, but I do pick up because it's all focused on extraterritoriality, of course, including her one finding in favor of the appellants that the it breached, or was ultra vires breaching the Constitution for the judge to conduct his business from Jamaica. In their notice of appeal, EB 277 to 282, to the Court of Appeal, ground B, proceedings from Jamaica, ground C, albeit later abandoned, establishing a court in Jamaica, and ground D, their legitimate expectation that they'd be able to present their evidence to the judge within the territorial boundaries, EB 277. And then, of course, the ad hominem argument that, well, it was only targeted at the judge because he happened to be abroad. My lady, before the board, EB 375 to 376, ground 1, outside the territory. Ground 2, B, location of judicial officers. Ground 3, the true purpose was to allow the judge outside TCI, creating a fiction that a place outside can be part of the courtroom. And then the reference to natural and ordinary meaning is that he would be sitting, or the judge outside. And then, of course, in terms of their equality of arms, the very short reference to ground 3 in their equality of arms, page 377, there's no mention about the extraterritoriality of that. So to succeed in this ground, learned friend would have, we submit, have to persuade you to reach the following conclusions: that the giving of evidence via the medium of video link is so inferior to in-person hearings that no judge should be allowed to exercise their discretion and jurisdiction to manage the process of the trial, of a trial, in accordance with fairness and the interests of justice. And if you found that, as a matter of fact, the giving of live link evidence, if you felt that you were able to do that, somehow undermines the trial process, you'd have to conclude that it creates an imbalance between the prosecution and the defense, so that the judge is barred from exercising his inherent jurisdiction to manage his own process in accordance, again, with fairness and the interests of justice. And in the context of this case, just a moment to reflect. The courtroom is huge, and the parties are sitting in rows that go back, I think, 7. I'm looking up at my juniors, I think, yes, that go back 7, and there are 2 banks with a corridor down the middle. The judge sits right at the back or front of the court. The witness is removed, in the sense, off to the right and quite a distance from the judge. Frankly, appallingly laid out, but big and capable of taking everybody. But importantly, everybody has spent the trial with a video screen which reflects the witness in the witness box. And many a time there has been a complaint, particularly from the back. We can't see because the video camera's gone off. I mean, they can, we would submit, but the complaint is they can't because the video's gone off, and they need the video screen to see the witness. The judge has a video screen of the witness box on his desk, as well as the screen with the documents. And I'm bound to say that if you're a note-taking judge, having the screen in front of you when you can look up whilst you're taking your notes to see the face of the advocate or the witness is a lot better for the working mind than it is to have to stop, look across, look at the witness, and forget where you were in your notes when you go back to them because you've just spent a few moments looking at the witness. Whereas if you're doing it as, and I don't know whether my lady will put on in this appeal, but if you're doing it as I imagine one would, with the screen in front of you, you can be making notes and looking up and down at the same time. I just make that point in passing in relation to the complaint that is made by my learned friends about wanting to be in the presence of the judge. To elevate this to the constitutional level that my learned friend seeks would necessarily draw into question the 2 points that I have made, one about Section 51 of the Criminal Justice Act, 2 about Scotland and cinemas, and indeed now the passing of the Juries Amendment Act here, 3, the Juries Amendment Act, which in short order simply provides, as I've said, for the jury to sit somewhere in another room to that of the judge. We submit that, analysed that way, the argument ends there, because it's a matter for the trial judge. But I've got to assume that the matter is taken on, and in that respect, I want, if I may, to make the following points. The Australian Securities and Investment Commission Get Swift case, which we refer to at 484 of the bundle within our written submissions. And if I can just forgive me just for observing, the air conditioning has gone off here, so we are beginning to boil beyond belief, but I don't suppose that's going to attract any sympathy at all. If I can just take you to this, paragraph 87, Australian Securities and Investments Commission Get Swift. I'll take it from our bundle, but if you want me to take you to the case, of course I will. I'd go further and say that, at least in some respects, it was somewhat easier to observe a witness closely through the use of the technology than from a sometimes partly obscured, and in this court, which I'm currently sitting in, distant witness box. In the Union Swiss case, which we highlighted and learned friend then picked up on in reference to another observation of Mr. Justice Chetty out of South Africa, he says this: the defendants do not proffer valid opposition to the logistics and mechanism proposed by the plaintiff. I'm not persuaded by their concerns over patchy internet connectivity, the spectre of load shedding, or the loss of opportunity to physically observe the demeanour of the witnesses. As the Australian courts have already stated, the judge may have a better opportunity of making these observations of a witness when they're captured on camera. And then, if I could ask you to turn to the electronic bundle, please, at 2223. Paragraph 30 in this is in the South African case. I just want to read this quote from Capique, which is also in our authorities bundle, but just simply this: these are not ordinary circumstances, and we've entered a period in which much that is around us and is going to continue to be unsatisfactory. I think we must try our best to make this trial work. If it becomes unworkable, then it can be adjourned, but we must at least try. It's obvious that whatever has happened since the pandemic has begun, in terms of the trial continuing, there was going to be a challenge. And I reflected on this over the adjournment, that if there had been no regulation 4.6 and the judge had said, I've got inherent power, I'm going to follow Endine and carry on, we'd still be here today. And against that backdrop, I just thought it helpful to reflect on a case, albeit it's a home court decision, but a decision of a judge sitting in Jamaica, when having to consider the issue of live link evidence. And could I invite my lady and my lords to, it's the case of Eugene Wilson. It begins at 194, but in particular, I would like just to pick up just some of the thinking, if only just to help our reflections. There is paragraph 14, always resistance to change, and no less so in relation to special measures. The foremost argument in this instance is that it infringes the rights of an accused person to confront his accuser, as guaranteed by the Constitution. The several accused persons are opposing the Crown's application for live link evidence. And then paragraph 16, making changes in the way we conduct trials and other court procedures has been a long and encumbered process. I say encumbered because changes are usually met with resistance, particularly in the sphere of criminal trials and particularly by accused persons. And then at paragraph 29, this reference, the judge refers to a case out of Ireland and then another case called Kimio Green. But what I want to emphasize is it's about 4 lines down. I am aware that similar issues will arise in the instant case, but this should not be a reason alone to refuse an application. I note, moreover, that in the instant case, the trial be conducted by a judge alone. A judge of the Supreme Court is a trained legal mind who is accustomed to conducting trial of serious offences, all without the assistance of a jury. There is a proven track record in this regard, as many such decisions as made by judge alone have been probed to the highest appellate level and have withstood such probing. Surely we can continue to have confidence in such a process. I add to that, of course, that in our trial, all the evidence is recorded both by video and sound. And so when it comes to the issue of demeanour, your ladyship, my lords, will be particularly live to the fact that demeanour, as much as it is becoming of diminished and diminishing importance in witness litigation in this day and age, cannot, we submit, in a document-driven case, be raised to be such constitutionally significant as to cause you to interfere with the exercise of a judicial discretion. We picked up on demeanour by reference to the case of Crown on the application of SS Sri Lanka and the Secretary of State. Could I ask you please to go to EB 1974? Out of this, we'll go back. 1974. And that's the beginning of the judgment. And if your ladyship, my lords, would go to our paragraph beginning on page 488, but over to 488, over to 489, you will see there that we make reference to paragraph 39, which is at 1985 in the bundle, which is worthy of consideration. To the contrary, on the issue of demeanour, empirical studies confirm that the distinguished judges from whom I have quoted were right to distrust inferences based on demeanour. The consistent findings of psychological research have been summarised in an American law journal. Do I need to read that, milady, or can I take that as read? Thank you. That is not to say, paragraph 40, that judges or jurors lack the ability to tell whether witnesses are lying. Still less does it follow that there's no value in oral evidence. But research confirms that people do not, in fact, generally rely on demeanour to detect deception, but on the facts that liars are more likely to tell stories that are illogical, implausible, internally inconsistent, and contain fewer details than persons telling the truth. And we submit that that is much more relevant and important. And again, on the same track, if I could take you to the House of Lords in Polanski and Condé Nast, and Lord Slynn who was one of the dissenting judges, but at 243 in the additional bundle. I think this paragraph commends itself to be read. Paragraph 43. It seems to me, however, do I need to outline the backgrounds of Polanski, or do I take it that just me mentioning the name and Condé Nast is enough to bring back sufficient recollection of the facts? I'm taking it that
particularly as I think your time actually ends at 3:20, doesn't it? Because you started 10 minutes early.
Yeah, so I think I've got another 8 minutes. So I won't remind you, but I do want to read this paragraph, if I may. And I'm pleased to say that I am going to finish just as I need to. It seems to me, however, that as a starting point, it's important to recall that although evidence given in court is still often the best, as well as the normal way of giving oral evidence, in view of technological developments, this is 2005, evidence by video link is both an efficient and effective way of providing oral evidence, both in chief and in cross-examination. Mr. Justice Eady's experience led him to believe that there is, in most cases, very little, if any, actual disadvantage or prejudice to either side when that means is adopted, and that my experience is that the process of cross-examination takes place as naturally and freely as when a witness is present in the courtroom. Lord Justice Thomas's opinion was very much to the same effect. It may be, however, that in different types of case, the balance tilts more in favour of evidence in a courtroom. It's been suggested, defamation, that I don't need to take you any further. In other words, it's a matter of discretion. And perhaps to make this point good, can I just take you to 2 paragraphs, Lady Hale in the Camberwell Justice's case about the youth justice provisions for remote evidence. Additional bundle 231. These paragraphs 57. It's paragraph 57 in the main. These are real problems, talking about defendants not having the same rights as witnesses to give evidence by remote link. But the answers to them cannot be to deprive the court of the best evidence available from other child witnesses, merely because the 1999 Act scheme does not apply to the accused. That would be to have the worst of all possible worlds. Rather, the question is, what, if anything, the court needs to do to ensure the defendant is not at a substantial disadvantage compared with the prosecution and any other defendants? And then this, that can only be judged on a case-by-case basis at trial and on appeal. This is led by us in support of our submissions that this is not a constitutional argument. There is no constitutional right to feel the presence of the court, or for the court to feel the presence of the defendants. Video links overcome that. And we submit, lady, that taking all those issues together, reflecting on Section 51, the cinema in Scotland, and the pandemic that we face, that a provision which permits a judge to determine in the exercise of his discretion whether or not to receive evidence by audio-visual link, whilst there are restrictions on travel and concerns about health, does nothing other than assist the trial process, which, after all, as the President of the Court of Appeal said, Sir Elliot Motley, that there is one other constitutional right which we've sadly overlooked since March, and that is the right to be tried within a reasonable time. Unless I can assist you further, those, milady, are our submissions.
I'll see whether anybody's got any questions that they want to ask. No, thank you very much indeed, Mr. Mitchell.
Thank you, milady.
So that leaves your reply, Mr. Fitzgerald.
Oh, yes. Okay, my lady. Well, can I start then with the question of the interpretation of Regulation 4.6? My learned friend first of all started about, well, why were they arguing about extraterritoriality? The answer is quite plain, that that's because Regulation 4.6
leads directly to an issue of territoriality if it is given its natural meaning. The natural meaning, and we've got regulation 4.6 at tab 11. The natural meaning is that the courtroom shall include, which means extend to, in my any place, whether in or outside of the islands. So we've got a place outside of the islands that the judge elects to sit. So it says that the judge can elect to sit in a place outside of the islands. That's naturally extraterritorial, provided always that the video and audio link facility at the said location, i.e. that place outside of the islands where the judge elects to sit, is accessible. It's plain that it's on its ordinary meaning. It is empowering a judge to say, I elect to sit here outside the islands. You must be connected to me and accessible to me. And then the courtroom will extend to what we say is what include means there, that place. And we respectfully submit that that's why the issue has been extraterritoriality, because on its plain meaning, the judge, by electing to sit outside of the islands, and that's the plain words of the statute, not some attempt to read in, zooming in and all that, the judge elects to sit outside of the islands, and then that location outside of the islands is the place that must be accessible remotely. That's why extraterritoriality has arisen, because on its natural and ordinary meaning, it means nothing but that the judge can sit outside of the islands and render that location outside of the islands the place to which the other participants must be remotely connected. And that's not fanciful. Perfectly possible for the judge to say, I'm going to sit in an office or a place in Jamaica, and you must all connect to that on a remote platform, and that's where I elect to sit. And that's why the issue has arisen, because that's what the plain meaning of the words is. Now, and my Lord Stevens put to my learned friend, well, how do you interpret it? The answer is, my learned friend has never explained how he interprets it. He's never explained what provided always that video and link facility at the said location. He's never told us what the said location means. It can only mean said location, i.e. the place outside of the islands where the judge elects to sit, not says, I will use that as the place from which I will remotely access the true courtroom, which is not outside of the islands, but inside the thing, and that said location doesn't mean what the said location says. What we have been doing, what we've been engaged in, is an exercise of trying to rescue sub-regulation 6. But with great respect, that's not a proper exercise. The plain and ordinary meanings of the words, as was recognised by the trial judge, as was recognised by Justice of Appeals Stolmeyer, and with great respect, as my learned friend pretty well recognised by saying I can't defend its natural and ordinary meaning, is that. But in any event, if this is going to be the basis, if Regulation 4.6 is going to be the basis for the judge taking the highly unusual course, I think probably unprecedented course, of conducting a criminal trial, not for an hour, not for a day, not for weeks, but possibly for months from outside of the islands. If that's going to be the basis of it, Regulation 4.6, we say it deserves some scrutiny. And if it doesn't stand up to that scrutiny, if it is either on its plain meaning conferring the power to sit extraterritorially and make that extraterritorial location the courtroom to which everybody else must have access, if that's the plain meaning, then we respectfully submit that cannot be a proper basis for the judge to sit remotely. And the reason why the focus of all the declarations sought has been on Regulation 4.6 is because when my learned friend made his application saying the judge can sit remotely, he relied on Regulation 4.6, not on ND, but on Regulation 4.6. That was his basis. So my learned friend said the court cannot sit in Jamaica, therefore it can't mean that. That is non-constat. According to Regulation 4.6, he can say, this is the place where I elect to sit outside the islands, elect to sit, i.e. I am sitting here because I've elected to sit here. And that is the location which I will make available to all those, to the court recorder, the interpreter, the parties, counsel and witnesses, and then everything will flow from that. So I do respectfully submit that none of the judges in the court below explained how actually they interpreted the words of the proviso, or how they interpreted the words, the place where he elects to sit outside of the islands. They simply took off into self-sustained growth by a series of references to the purposive approach. So you say the purposive approach means that the regulation means what I think it should mean, because that would be consonant with the Constitution. But none of them did the hard work, and nor is my learned friend, of explaining, well, where is this place outside of the island where the judge elects to sit? Elects to sit, not uses as his base to zoom in, but elects to sit. Where is this location outside of the islands, which must be accessible remotely? So now, my lords and my lady, if the answer to this is, well, it's highly unsatisfactory, but we have to do the best we can, we respectfully submit that if this is going to be the basis for a wholly unprecedented conduct of a very important criminal proceeding, the answer is you don't have to do your best. You can strike it down and say, go back and do it again properly, and lay it before Parliament. The governor can do it again, do it properly, lay it before Parliament, and subject to their negative resolution, and see whether that withstands scrutiny then. But I don't accept that one simply reaches a stage where you say, well, the trial's got to go on, so we better interpret it some way that it enables the trial to go on, which is really, in the end, what my learned friend was saying. There is, we respectfully submit, as Justice of Appeals Stolmar recognised, a total lack of coherence in Regulation 4.6, unless you interpret it as saying the judge can say, here I am in Jamaica, I've elected to sit here, you can all, in a courtroom here or whatever, an office here, you can all zoom into me, it's accessible remotely, that's where the court will conduct its business from. And my lords, that is, in our respectful submission, not consistent with a principle and not consistent with the constitutional inhibition on sitting outside the islands. It is about sitting, because that's the word that's used, elects to sit. My lords, that's how we respectfully invite the court to interpret those words. Now, my learned friend says Regulation 4.6 was not designed to create a new jurisdiction. We say on its plain meaning, Regulation 4.6 was designed to permit a judge to exercise its jurisdiction, his jurisdiction, from outside the islands. And that is unlawful. That really is what we submit. On the Supreme Court ordinance, yes, oh yes, sorry. Section 3 of the Supreme Court ordinance. My learned friend says, well, that's about the jurisdiction of the court. I don't think I have to take you back to it, my lady. The Supreme Court ordinance saying that it's the same, has the same jurisdiction as the High Court in England and Wales. It's right that it's about jurisdiction, but the jurisdiction of the High Court in England and Wales is dependent on where you're sitting. And they may sit in England and Wales, and we say nowhere else. So we say that the jurisdiction is a dependent jurisdiction, which depends on you sitting in England and Wales. And my learned friend, he dealt with the Criminal Justice Act 2003. We say that there is, and he relied on that. Perhaps it's best to say that if we need to interpret exactly what Section 51 provides, that may come at another time. But Section 51(1)(a) provides for a direction to be made. So this is at the additional bundle, for a direction to be made under this section may be given for a judge or justice to take part in eligible criminal proceedings through a live audio or video link. But no direction in this may be given for any member of a jury to take part for a live audio or a live video link. So the jury can't participate for a live video link. The direction can be given for a judge or justice to take part. But it doesn't say that they're going to conduct the whole proceedings, the evidentiary part of the proceedings, via a live video link. So it doesn't extend as far as Regulation 4.6. In any event, it's much more clear what it is saying than Regulation 4.6. My learned friend then dealt with the coercive powers and the President's judgment, Mr. President Mockley's judgment. And he there said, there is but courtroom, and the judge is to conduct it from that courtroom. Well, any courtroom mentioned in the 4.6 is the courtroom where the judge elects to sit. And that is the location referred to. So I respectfully submit that again, this was a case of the President, with great respect to that most distinguished judge, just simply legislating, not interpreting the words of the statute itself. I have to accept that my Lord Briggs put forward an interpretation as to what the words could mean, that where the, can I just try and get it, if where the judge elects to sit is the place he's at, it's deemed to be the courtroom. But I respectfully submit that doesn't give due force to the courtroom shall include, which we say just extends to any place out, and it can be outside of the islands, that the judge elects to sit. And then one has to make sense of the words at the said location. There's only one location, and that's where he elects to sit. So
can I just interrupt for a moment to take you back to what in a way you're treating as the Parent Act, which is the Senior Courts Act, Section 71, yes, about sittings at the High Court, yes, which is at E928.
I'm so sorry.
928 of the electronic bundle.
Yes, yes.
Can I just ask you this?
Yes.
If a judge is on duty, as they can be, in their own home, and they make an order, where is the order made? Where is the judge sitting?
They're sitting in that case. They're sitting. The High Court is in their home. Yes.
Okay. So where are the rules of court that authorise that in terms of domestic procedure? Because if you see 71(2)(a), it yes, requires that it be determined by the Lord Chancellor after consulting with the Lord Chief Justice, where the High Court can sit outside the Royal Courts of Justice.
Yes. Well, I'm very sorry, my lady. I don't don't have those rules. But
Or might it in fact be the case that the judge is sitting in the centre, even though actually hearing the case sitting in their own house?
yes, so they're deemed to be hearing it from the Royal Courts of Justice, although yes.
Yeah. So
Well,
why is that so far removed from Regulation 4.6?
Well, the difference is it doesn't say outside the jurisdiction, I suppose.
Yes, so it's not to do with that, is it? It's to do with where is a court sitting. If a judge is not in the physical building.
Well, the judge is electing to sit at a place outside of the island, and then that location is a place which must be accessible. I respectfully submit that just it does presuppose, if 4.6 is given its sensible or its logical interpretation, it does presuppose that the judge says, let's say, this office or this place will be where I elect to sit. It is the court, but it must be accessible. It must be accessible by all the. This location must be accessible remotely to the court recorder, etc. It doesn't. There's nothing there to suggest that there is somewhere other than the place where the judge elects to sit, i.e. the location outside the islands where he locates to sit, which is the true courtroom. My lady, I don't know whether that...
You wouldn't use the word include, the courtroom includes then?
Well, my lady, I respectfully submit that include really means extends to, because you have to say that, because you're saying there's the formal conventional courtroom in provinciales, but the courtroom can also be a hotel, a church, or a place outside of the islands where he elects to sit. That's how I put the include is. It's been given a lot of significance in the Court of Appeal's judgment because they were desperately trying to find some way to justify their strained interpretation. But actually, it's just as consistent with that. You just say the courtroom will include a church, a hotel in the islands where you elect to sit, or a place outside the islands where you elect to sit. It doesn't bear the great significance that has been attributed to it by the Court of Appeal, in my respectful submission.
Thank you very much.
Well, now, my lady, then my learned friend went into, as the Court of Appeal did, a great deal of discussion about the practice direction. Can I just make my response very clear? Why are we looking at a practice direction issued pursuant to these regulations 3 days after these regulations went through as a key to the interpretation of these regulations? That is completely back to front and upside down. It reverses every canon of construction. That you look to a subsequent thing done by someone pursuant to these powers as the means of interpreting a thing done 3 days before by a different body. I mean, that really is. And then it's all described as, well, it's all part of looking at the context. Well, you can look at the background context, but you can't look at the as it were, futuristic context and somehow say, well, they must have known that that's what the Chief Justice was going to do, and therefore they conformed their wording. Sorry, Lord. My Lord, please.
I wonder if that submission can be carried a bit far. This was all done, no doubt, under considerable pressure of time as part of a coherent scheme for enabling the rule of law and the administration of justice to continue during the pandemic. And it's clear from the regulations themselves that the scheme was to include not merely the regulations, but the practice directions and so forth issued in accordance with it. It seems pretty likely that the two were being drafted more or less at the same time, and the fact that they were actually implemented 3 days apart may be no more than happenstance.
Well, it would be necessary as a matter of law that the Chief Justice couldn't start drafting, well, he couldn't
He could, but surely he could start drafting them. He just couldn't issue them.
Yeah, sorry, I'm so sorry. Yeah.
Yeah,
Well,
so am I.
Well, my lord, I do respectfully submit that it is just wrong in principle to interpret this regulation by reference to something done pursuant to it by a different decision maker subsequent. And I'm not sure that it would be proper to assume that they'd all been discussing how it's going to be done in advance. But well, that is my submission in response. If I've gone too far, I apologise. But I think that is it is. I've never seen that notion as a. You look at the background and the context, but you don't look at the subsequent developments. So I respectfully submit that Regulation 4.6 therefore is ultra vires and unlawful. And then in my submission, one's left with the Endine case and the principle in Endine. In the Endine case, as one can see from tab 45, but the two jurisdictions, British Columbia and Ontario, both had a section 12, a statutory provision, and that set out paragraph 4 of the judgment. So the judgment was essentially about you can do this by way of section 12, because Quebec had dropped out of it. But it too had a version of section 12. So it was the ratio that you shouldn't resort to the inherent jurisdiction if you can do it by way of a statutory power that relates specifically to class actions. It's true that obiter at the end, the Supreme Court then talked about the inherent jurisdiction. Now, my learned friend says, well, they left intact what the Court of Appeal had said. But in our respectful submission, what they did was to indicate that there had to be limits to this principle. And the limits were those set out that it shouldn't be coercive and that it should only be in this particular type of case, and that they wouldn't go further than that. But my learned friend makes the point, well, what's wrong with the notion that by beaming in, you are in fact acting in the court, in the jurisdiction in any event? And my respectful submission in response to that is, in the absence of express legislative authorization to permit a judge to conduct a trial remotely by reference to this notion found in what I'm going to describe as an obscure Court of Appeal decision in Canada, would be pretty strange to say, well, we'll find the authority for this to conduct the trial in this way in the Court of Appeal judgment in a totally different context in Endine. And then finally, there's the question, well, what's wrong with the principle? And I respectfully submit that it's just wholly inappropriate to a criminal trial to say, well, it can be conducted without any statutory authority, because Regulation 4.6 doesn't provide it, by a judge zooming in from abroad. And so that's my response to my learned friend's arguments on Endine. And then finally, so if we are right, the fundamental principle that Regulation 4.6 offends is in providing for a judge to make the court centre abroad. And that is a fundamental principle, and that's why we say it deserves the protection of the law under the Constitution. Finally, to the question of the inequality of arms, and we do submit that that does derive its separate force from the fact that we're halfway through a trial. After all, it's not that unusual to say that it's okay to start a trial and conclude it on a new basis, but it's wrong to suddenly change horses halfway through a trial. That's
Mr. Fitzgerald, I think you've got a question from Lord Stevens.
Oh, I'm so sorry, Mike. Sorry.
The difficulty, Mr. Fitzgerald, that I'm struggling with is I know nothing about this trial. The expert in this trial is the trial judge. I don't even know whether this is a case which is going to be determined basically on the papers and the evidence. This is a matter of discretion for the trial judge to consider the fairness of the trial. And so I'm having difficulty at the moment in seeing how the board can say that no judge can exercise discretion in this case.
Well, my lord, I suppose that how we put it is in this way, that to introduce a power to depart from sitting in the Turks and Caicos Islands for the criminal trial that can be applied halfway through the trial is of itself productive of inequality of arms, because it provides for a complete alteration of the way the trial is conducted halfway through the trial. I mean, my learned friend was good enough to indicate that it obviously, the judge has indicated at least a readiness to continue this lengthy trial, or to consider continuing this trial in this way. And so, my lady, what we would say is typically you'd have a transitional provision or a commencement provision, which would make it clear that the innovation would apply to future trials rather than existing trials. But to introduce this very significant innovation halfway through a trial, and I accept I have to put it this way, is of itself leads to inequality of arms. I think my learned friends said that it has to be of itself self-evidently unreasonable, and we would say self-evidently unfair, because the judge is empowered to completely alter the way that the trial is conducted. But I think that's how I have to put it, my lord, in response to your question. And I submit that for the governor, backed up by the legislature to the extent that they didn't abrogate the rule, to introduce this potential for a radical change in the way that the case was conducted at this stage naturally creates the potential for an inequality of arms. I think under the Constitution, it has to be the rights have been, are being, or are likely to be infringed under Section 21. So I say that this creates a risk that the rights will be infringed by the exercise of this power. My lord, so that's my answer to the point. Well, leave it to the judge in the exercise of his discretion. And I accept my lady and your lordships have limited information, but you do have some information about the scale of the trial, the length of the trial, the number of witnesses, and the fact that the hearing has to this stage taken place with only with all the witnesses being heard in front of the judge and in front of the defendants at the same time. I mean, with their co-presence in the same space, I suppose. My lady, I think those are the points that I can make. Can I just? Yes. So those are my respectful submissions, and we invite you therefore to strike down Regulation 4.6 in any event, and uphold the original judge's decision in that respect, and also to hold if that's an alternative route. Although my learned friend has never put it as a freestanding argument, that the Endine solution is not a solution. My lady, those are my submissions.
Thank you very much indeed, Mr. Fitzgerald. Shall I just see if anybody has anything else that they would like to ask before we conclude? No, I don't think so. So it remains for me to say a grateful thanks to, I can see Mr. Mitchell wants to say something.
I simply this, lady, and I'm sorry, but you appreciate we've been adjourned since March, and you will appreciate the judge has indicated to sit on Monday, and I just simply was inviting you to consider whether there is something of an update that I might be able to give him.
I was going to deal with the question of the the board's knowledge of the urgency with which this matter is viewed, but equally you'll appreciate that we need some time to consider what the position is after we've heard your submissions, which is only just concluded. So I think the answer to that is not right now, Mr. Mitchell, but we're conscious of the need to get on with this matter in one way or another. So can I thank everybody for the assistance we've been given in reaching a decision about this by all of the submissions. I know that it's not just the people we can see on the screen, but those who are assisting either present in the room or behind the scenes. So we're grateful to them as well. And we will attempt to let you know as soon as ever possible what the situation is. Thank you all very much indeed.